Not every judge or attorney actually knows this. I've had to actually remind judges in the past, hey, I don't need a change of circumstance for us to readdress bail. Once somebody is detained in custody for want of bail or because they can't afford the bail that's been set, that defendant is entitled to an automatic review of the judge's decision within 5 days. What this means is the defendant gets not one, but two bites of the apple at the initial stages of the case in the same court. It doesn't require you to file an appeal to a higher court. They're entitled to a review of that decision within the same court they're already at. The prosecution at the first court date has probably had a lot more time to read over the police reports, to go over the evidence they're using to base the case against the defendant. After all, they're the team that decided to file the case. They're the ones who have the more direct interactions with law enforcement. And this is important because going into a bail hearing, the judge is supposed to start off by assuming the allegations against the defendant are true. And then when we start with that, where does it leave us when it comes to the calculation of public safety, the risk the defendant might flee, things of all that nature? It's really hard to have that conversation fully and fairly unless both sides have had some equal opportunity to review the evidence that is being used against the defendant. This automatic 5-day review from the first court date guarantees that the defendant will have at least some ability to go over what the case is actually about before having some intelligent and potentially final discussion of bail in open court.